All right, hello everybody. Good afternoon, everyone. Happy Friday on this July 21st, 2023. I hope everyone is able to enjoy the nicer weather that we're seeing outside today, whether that's on a bike ride maybe, or just a stroll around the block. Hello, my name is Nick Altman. I'm the HOA Information Officer with the Colorado Division of Real Estate. You've joined one of our monthly HOA forums, where we discuss various topics of interest. Today's forum is on the 2023 legislative session, where we will be discussing the bills that both directly and indirectly affect HOAs in Colorado. Joining me today is Amanda Lopez, the HOA Program Assistant, and David Donnelly, the Education, Communication, and Policy Manager for the Division of Real Estate. Hello, David and Amanda. Thank you for being here with us today. Amanda, you seem to be muted.
Sorry, guys. Thank you guys so much for joining us. Happy Friday to all. And I look forward to this forum with you guys.
Good afternoon, everybody. Thank you very much for joining us. Looking forward to this. We have a lot of attendees. So, Nick, I'll pass it back to you and let's get going. Thank you very much, everyone.
All right, perfect. So just a couple of housekeeping items before we get started here real quick. Today's presentation will be recorded and uploaded to the division's YouTube channel. You can find the link to our channel at the end of this presentation, where you can see videos of our other HOA forums, as well as tons of additional information and resources on HOAs and other real estate topics. For this presentation, the chat function is enabled. If you look at the bottom of your screen, you should see the chat icon. And if you click on that, you can pose your questions right in there. Throughout the presentation, we'll do our best to answer your questions as they come up. If we don't get to your question, feel free to send us an email and we'll address it after our discussion today. Lastly, the slides and a link to this video will be posted on our website within a few days. All right, so just as a quick refresher, I'm sure most of you already know this, but what is the HOA Information and Resource Center? What do we do and what do we not do? So what do we do is in green there. We provide information to homeowners regarding their basic rights and responsibilities under the Colorado Common Interest Ownership Act, which is commonly abbreviated KIOA. We gather, analyze, and report information through the complaints and HOA registrations. We create resource materials. We provide education and forums. We provide a website with information for the general public. We register HOAs pursuant to Section 401 of KIOA. And we also provide an annual report to the legislature. What we do not do here is we cannot provide legal advice. We do not act as an advocate for any one party. We cannot assess fines or penalties. We do not enforce an HOA's failure to register. We do not mediate or arbitrate. And finally, we are not a regulatory program. As always, the information provided during this presentation is for educational purposes only and is not meant to provide, nor should it be construed as legal advice. Any legal questions you may have should be directed to a qualified attorney licensed in the state of Colorado. All right, I'm going to turn my video off here. So the purpose of this presentation today is discuss the legislative changes implemented by the Colorado General Assembly during the last legislative session, which affect common interest communities in Colorado. Each year, the Colorado General Assembly holds a legislative session. The General Assembly convened for the 74th session on January 9th, 2023, and adjourned on May 8th, 2023. As a result, numerous laws that affect the HOA industry, both directly and indirectly, became law. You might be joining us today as a homeowner residing within an HOA, a member of the executive board of a homeowners association, a community manager working for the executive board, an attorney, or maybe a licensed real estate broker. Whomever you represent, understanding these new bills, when they take effect, and how these bills affect HOAs is important. So I'm going to do a quick poll here. Just want to see who's joining us today. All right, great. Looks like most of those joining are either homeowners living in an HOA or members of an executive board. I'm going to share these results here. All right. So the acts we'll be discussing today are laid out on the screen here. That way, if you want to view the recorded video later on YouTube, you can skip ahead to the section you're most interested in. So the acts are Senate Bill 23, and for your information, 23 just means the year, so that's 2023. Senate Bill 016, House Bill 1068, House Bill 1233, House Bill 1287, Senate Bill 178, House Bill 1174, and finally House Bill 1105. I also want to mention real quick, we tend to talk a little fast. So if there's something we missed or you would like for us to repeat, please feel free to let us know in the chat. So with that, I'm going to hand it off to David Donnelly to discuss Senate Bill 23-016. David.
Thanks everyone again for joining us. I really appreciate your interest. So the first bill that we're going to talk about today is, as Nick mentioned, SB 23-016. The formal name for this bill is Concerning Measures to Promote Reductions in Greenhouse Gas Emissions in Colorado and in connection therewith making an appropriation. Next slide, go ahead, Nick. So SB 23-016 was introduced in January, on January 10th, and it was ultimately signed into law on May 11th, with an effective date of August 7th of 2023. Generally, what this bill does is it addresses various climate goals for the state of Colorado that have been identified by the Colorado General Assembly. So by and through the Colorado Energy's office, the state of Colorado is tasked with specifically with working with communities, utilities, as well as private and public organizations to attain those goals. Next slide there, Nick. For the purposes of the HOA Center, though, and because that's what you're here for, right? The following sections of the Colorado Revised Statutes have been amended by this bill. In Kiowa, the Colorado Common Interest Ownership Act, it was amended to clarify the definition of what an energy efficiency measure is, and this language is very subtle. It's the previous language. What it stated was it simply said a heat pump system. Great, but what is a heat pump system? That's my question, and I think that's exactly what the question of the legislature was. So they amended the language in Kiowa to read to be a heat pump system as defined in section 39-28-732 sub 2 sub C of the Colorado Revised Statutes, and so it defines further what a heat pump system is. Some of you might be familiar with heat pump systems. Historically, I mean, they've been around for decades, and they can be used not only for heating, but also for cooling. And over the years, technology has advanced significantly with respects to heat pumps. And so they really are, I mean, in my humble opinion, they are a viable alternative to traditional air conditioning, traditional furnaces nowadays. So, so that's again my 2 cents. Whether you seek that or not is in your own homes and in your own communities. We'll leave up to you. But references to this term energy efficiency measure can be specifically found in Kiowa at 38-33.3. 106.7. And then the bill also explains now that a heat pump system, as defined by that section 3926.732, is also construed or as part of the definition of what we refer to as a renewable energy generation device for purposes of that. Again, so remembering the purposes, the goal, the legislature's goals in this case were to create incentives and expand the energy efficient measures, as well as the definition of renewable energy generation devices. With that, Nick, next slide, please. Oh, and I'll pass it back to you for this guy.
All right, thank you, David. So this next bill concerns pets, and while it's not entirely related to HOAs, there are certain sections that you should be familiar with. So the title of this bill is concerning pet animal ownership and housing, and in connection therewith, prohibiting restrictions on dog breeds for obtaining homeowners insurance, providing for the manner in which pet animals are handled when a writ of restitution is executed, limiting security deposits and rent for pet animals from personal property liens. So, all right, so Kiowa does not actually address any limitations on pets, but there are a couple of key considerations here on House Bill 1068 that you should keep in mind when drafting or enforcing any pet policy the HOA may currently have. So just some higher level facts here. It was introduced January 19th, 2023, signed June 7th, 2023, and the effective date is January 1st, 2024. So first, there are just kind of four components here that I'll try and get through quickly. Homeowners insurance. The bill now states that insurers may not, 1, refuse to issue, cancel, refuse to renew, or increase a premium or rate for homeowners insurance, or increase a premium for either homeowners insurance or fire insurance based on the breed or mixture of breeds of a dog that's kept at a dwelling. However, there's one exception, that is if the dog is considered to be a dangerous animal, or if the particular dog has been declared to be dangerous in accordance with section 18-9-204.5. And I know I don't have the statutes on the screen there, but for your information, feel free to email us and I'd be happy to send you those statutes. So the insurer may not ask about the breed or mixture of breeds of any dog, except if the dog is known to be dangerous. Number 2 there is execution of writs of restitution. Basically, the writ of restitution is a court order to remove tenants and their possessions from a rental premises, relevant to landlord and property managers. House Bill 1068 here directs the officer executing the writ to inspect the premise for any pet animals. And at that time, the officer must provide any pet animals found during the inspection to the tenant or contact a local animal control authority. Kind of moving through here, we have number 3, security deposits. A landlord may charge no more than $300 from a prospective tenant or current tenant to allow a pet animal to reside at the premises. It also says that the security deposit must be refundable to the tenant, whereas previously many landlords required non-refundable security deposits for pets. D here, additional rent. A landlord's not permitted to charge more than $35 per month or 1.5% of the monthly rent, whatever is greater from a tenant as a condition of allowing that pet animal. Finally, landlord liens. Section 38-20-102 CRS creates a lien on the tenant's personal property that is then on or in the rental premises. The lien's effective upon household furniture, goods, appliances, and other personal property of the tenant and the members of the tenant's household then being upon the rental premise, but exclusive of pet animals. So again, if you need me to repeat that, or if you need more information, feel free to send us an email. And it's also posted on our website, a summary of these bills. David, this next one's for you.
So before I jump into House Bill 23-1233, there's two quick comments I wanted to make. As you listen to Nick's comments there on the previous bill, you might have said, well, what did that have to do with HOAs? Good point. Very good question for you all to ask. The previous versions of that bill had a lot of language that pertained to HOAs in particular. And so, so we felt that it was important to include that bill simply because of we've received several inquiries from the public saying, what does House Bill 23-1068 have to do with my HOA? And that's because they had been looking at previous versions of the bill. Ultimately, what finally was passed by the legislature and signed by the governor, those provisions that directly pertain to Kiowa were removed, but nevertheless, I mean, with the amount of rental, the prevalence of rentals in the state of Colorado, we felt that it was still very important to include that in our presentation today. The second point that I wanted to talk about before I jumped into 1233 is you're going to hear Nick and I talking about the effective date on all of these bills. All of these bills, we're trying to provide you what appears to be a hard and final number, or a hard and final date. However, we have something in the state of Colorado called the safety clause, and that safety clause is a reference to our Colorado state constitution, and the state constitution allows, subject to something. Let's just say I didn't like House Bill 1068 for whatever reason. If I could go get the proper adequate number of petition signatures, I could challenge that and bring these bills to a referendum of the people at the next election, which would be, of course, this upcoming November. So, bearing that does not happen, which it can happen, although it is relatively rare in the state of Colorado that does happen, those referendums, that is, these would be the effective date. So I just wanted to add that caveat to everyone, so that if down the road something changes and it does go to a referendum, this information would, of course, at that point be invalid, because it would be subject to the results of the referendum at that general election. So food for thought. So with that, 1233. This bill, I mean, it has an exceedingly long name that I'm not going to bore you all with there, but the long and short of it here is that it pertains to electrical vehicle charging stations, and in particular, it pertains to those in multifamily buildings as well as common interest communities. So keeping that in mind as we go on to the next slide here, Nick. So the General Assembly, similar to the last bill that I presented on, has identified a good series of goals, and one of those goals, as it pertains to 1233, is a reduction in greenhouse gas emissions, and therefore the promotion of vehicle electrification. Those are two key strategies for the transportation sector. HB 23-1233, what it does is it acknowledges that it's less expensive to build electric vehicle capable parking at the time of initial construction rather than through retrofitting at a later time. And I think that can make sense to all of you. I mean, once the infrastructure is in, and let's say if I want a vehicle charging station on the far side of the parking lot, that means tearing up the entire parking lot in order to install that. If we consider some of these steps at the time of initial construction, then it's going to save money for the developer and ultimately for you, the homeowners, in these cases as well. So, but some of the simple stats. The bill was introduced in March, and it was signed by the governor on May 23rd. Again, and now in this case, the bill is effective immediately, which is again still subject to that safety clause that I referenced earlier. However, we would see these going into effect now, and so I point that out here because board members and community association managers, as well as community common interest attorneys, common interest community attorneys that are with us today, should take into consideration reviewing their governing documents and in particular their governance policies that are set forth, are required by Kiowa, to help ensure that these policies that your policies can comply with this new law. Next slide there, Nick. With HB 23-1233, I mean, it's a pretty large bill, and it addresses various facets of housing and as well as administrative law. So some of the provisions in this bill don't really apply to common interest communities, but in particular, there are a few that do. First of all, the state electrical board is directed to prepare rules that surround the EV power transfer infrastructure for multifamily buildings, as well as rules that apply to, and these rules what they do is they apply to both new construction, but also major renovations of multifamily buildings. So if, for instance, we were in a situation where you were going to perhaps repave or redesign a parking structure in your common interest community, that might trigger this bill for you. So again, something that boards, CAMs need to consider as we're moving forward here. So, but it does somewhat depend on what rules are created by this process in order to determine exactly what that's going to look like. So we'll have to stay tuned in order to figure out exactly how that's going to work. But what we do know as of right now is that a major renovation project is defined as a change to at least a 50% of a parking area. So if you're repaving a small corner of your lot, that's not going to trigger this bill. But 50% or more of your parking area is, and again, they use the word change. They don't say you have to tear down the parking structure or something like that. This could be as simple as a repaving project at that point. So, boards need to keep that in mind. So what this bill does is addresses both the rights of tenants to install a level 1 or a level 2 charging station at their own expense. And briefly, let me explain. A level 1 parking a charging station is basically a 120 volt regular old plug type charging station. A level 2 is a 220. So some of you, if you have an electric dryer, an electric stove, you might have those much bigger plugs. That's a 220 plug. So that's what we would refer to when saying level 2. There are other standards as well, but this bill only pertains to level 1 and level 2 charging stations. So a lot of you at this point, you probably, before I broke down what a level 1 and a level 2 is you said, you might have heard me say tenants. And so you might ask me, why are we talking about tenants when we're supposed to be talking about HOAs? And I think that's a good question for you to all be catching on to, and we will get to that in a moment. But it's important for you to know that the rights of a tenant apply whether or not the lease premises is located in an HOA or not. That is irrelevant. The law also says that tenants have a right to install these charging stations in both residential properties and commercial rental properties. So some of you that reside in common interest communities that are mixed use, this would apply even to your commercial tenants. Next slide, Nick. In a common interest community, boards and their CAMs are no longer allowed to prohibit the installation of a level 1 or a level 2 charging system for their owners. So a unit owner now has the right to install a charging system either in their own unit, think i.e. a single family home, 2, in a signed or deeded parking spot that is part of or assigned to that unit. That means that you own unit 202 and parking spot C16, for instance. That would be what we would refer to as a limited common element of the community. And then thirdly, a parking spot that is accessible to both the unit owner and other unit owners. So this, then what that means is that it applies to general parking lots, unassigned parking spots, basically a free-for-all. So, and in which case boards would certainly want to consider some reasonable aesthetic provisions that would make it more both aesthetically pleasing, but also more convenient from a cost perspective and a parking perspective on the installation of those in a general parking lot that does not have deeded spots in as such. So, but again, I just said something about reasonable aesthetic provisions. Boards still may enforce reasonable aesthetic provisions that govern A, the dimensions, B, the placement, or C, the external appearance of an electric vehicle's charging system. So that could include something that means maybe we have to have a fence around a charging station, or something to that extent, or that it has to be in a certain area of the parking lot that is not going to, certainly what's something you want to take into consideration, not block handicap accessibility or take over or inconvenience handicap accessible parking, for instance. But the word reasonable in that reasonable aesthetic provisions is very important. All of you board members out there, we can't tell you what reasonable is. And for anyone that's called our office before, we've probably given you this explanation. We are not the determination police. We don't get to decide what is reasonable. Who does would be ultimately a judge. So for both parties, a homeowner as well as a board in these situations, I would most sincerely encourage you to try to keep that standard in mind. Think about what a judge would say. A judge who has no skin in the game, are they going to think that what you board members, what you're arguing is reasonable? Will they agree? Think about it from an independent third party's perspective, and the same advice certainly goes for a homeowner that's requesting this accommodation, or that is requesting the installation of a charging station. Consider what a judge would say is reasonable. Just because it's comfortable and convenient for you might not mean that it's the only reasonable option. There's some give and take there for your boards to consider. And again, it's best if you're able to decide this information outside of court between you as parties, rather than getting to as far as to a judge. So I'd like to talk about a quick scenario. So let's pretend that I'm a tenant in an HOA. The HOA has a parking lot with no reserved spaces other than those handicap spots that I mentioned a moment ago. And I'd like to install a level 2 charging station essentially in the parking lot. As a tenant, I know that I have the right under this bill to install that at my expense. What's my first step going to be, though? My first step is I'm going to call up my landlord, because I don't have the right as a tenant to show up at your board meetings and say, this is what I want. So I'm going to reach out to my landlord and share my intentions. What if my landlord says, well, hey, David, I love electric power. I have an EV myself, but I talked to the board when I lived in the property a couple of years ago, and they said no at that time. So end of conversation? No, it isn't. It is absolutely not the end of the conversation. Just because your owner, or even you for that matter, as a tenant, asked for this installation some time ago is irrelevant. So what the proper procedure would be here is for the tenant to share their intentions with the landlord, and the landlord to pass that information on to the board. The board has the right to enforce those reasonable aesthetic provisions, but they cannot, all capital letters there, cannot prohibit the installation. And so neither the landlord nor the association has the ability to say flat out no. That is unequivocal and unquestionable at this point. They have the rights to putting certain reasonable aesthetic provisions on it, but they cannot say no. So again, I want to reiterate that boards management companies and community association attorneys should really take a good look at your current rules with respects to this, so that you can, in order for you to avoid an issue where this comes up, whether that's 6 weeks from now, 6 months from now, 6 years from now. If you have rules and regulations and policies in place, and then you act on those as a CAM, as a board, then your decisions very likely would not be found to be arbitrary or capricious. But if you simply say, well, I don't really like David, so I'm going to say he has to have his way over in the back far corner and pay $500 worth of fencing to cover it up and make it so that it looks pretty and or what have you. But then somebody else in the community that I do like, or that they do like, they say, oh yeah, you can have front row access, no problems. That's going to be likely be determined to be an arbitrary and capricious action by the board. So you want to act uniformly across all of your homeowners in these scenarios in enforcing your rules. The best way to avoid arbitrary or capricious behavior is to have rules written down, share those rules with your community, and follow those rules as you're making decisions. With that, I'm going to change gears, and I have the next bill to chat with you about, which is House Bill. So yeah, next slide there, Nick. Thank you. House Bill 23-1287. This one's a little shorter name. It's concerning county regulations, concerning county regulations authority to that is related to short-term rentals of lodging units. So, like some of the other bills that we've talked about, this bill does not change Kiowa. However, based on the number of inquiries that we receive regarding rentals on in the HOA Center, we wanted to bring this bill to all of your attention. So next slide there, please. So all of us that are residents here in Colorado know that Colorado is a very tourist-friendly state, and short-term rentals are proving to be more and more lucrative all across the state, both in the metropolitan areas as well as the rural and recreational areas, the ski towns and the like. So, because of the frequency that I said that we hear about or receive inquiries about short-term rentals, let's discuss a little bit about 1287 briefly. So this bill was introduced in April and signed in June, and again, it has an effective date of August 7th. Next slide there. In Colorado, short-term rentals are regulated on the local level, not at the state level. Just as a reminder for those of you that are new, the HOA Center is a division of is a program within the Division of Real Estate, which is a state-level entity. So I just want to draw that distinction real quickly. But this bill specifically identifies short-term rentals as, quote, purely a local concern, unquote. So that means that it's not within the purview of the state to pass regulations on. That means who gets to? Or I guess the question is then who gets to? Counties get to license that, and they get to regulate owners or owners' agents that rent or advertise owners' lodging for short-term rentals and vacation rental services. These regulations vary from state to state. So as much as Nick would love to be able to help you all, if you just call him up and say, hey, I live in Summit County, what are the rules? The best that we can do is refer you to the county, because we don't, because that is outside of our purview. We want to help you, get you the resources, point you in the right direction so that you can find those rules, but we're not able to interpret them. We're not able to tell you what they are. They vary from county to county. So, so always check with your local county and in some cases the municipality as well, so that you can better understand what your local regulations are. But this bill talks about owners' agents, and the Colorado Revised Statutes does define what an owner's agent is, but it specifically exempts something we've referred to as vacation rental services from the definition of what an owner's agent is. A vacation rental service provides additional services for the owner that are related to the owner's lodging, but unrelated to providing a means of offering or lodging for that unit. So what that means is that when we're if in order to be a vacation rental service that is not would not be regulated on the county level, think VRBO, think Airbnb, to just name two of the big ones out there. If they're not providing the other services other than simply marketing it for rent or for lease for lodging, if they're offering cleaning services or repair services akin more to a property manager, then they would not fit into the realm of, or into this exception to the definition of for vacation rental services. But there are many real estate agents out there that may offer some of that more full service experience, and those would be construed as owner's agents for purposes of this bill. So, but the real takeaway here is that each and every county has different regulations, and how they enforce those regulations and what the fees may cost vary from county to county. So I strongly encourage anyone that is interested in short-term rentals to become familiar with your local jurisdiction's ordinances and regulations. And with that being said, community association managers as well as boards, I would encourage you to also follow, to be aware of what those local regulations are. Now that this bill has expressly put that 100% wholly on the counties in each case. With that, I'm going to pass it back to Nick for one of the more important bills, in my opinion, that we've got going on with this legislative session.
All right, thank you, David. I know there were a couple of questions in chat there related to the House Bill 1233 and also the short-term rental bill. Okay, so the next bill that we're going to talk about is Senate Bill 178, concerning removing barriers to water-wise landscaping and common interest communities. Sorry, that number took a minute to pop up on the screen there, but all right, so let's talk about the water-wise bill. So this bill was introduced on March 3rd, 2023. It was signed on May 17th, and the effective date is August 7th, 2023. So water conservation, as I'm sure everyone is aware of, is a top priority for the state of Colorado. The intent of this bill is to make it easier for unit owners and boards alike to conserve water in their communities. So basically, in a nutshell, what this bill is doing is allowing owners, unit owners, greater flexibility in deciding whether to install xeriscaping, non-vegetative turf grass or drought-tolerant vegetative landscapes on a property that unit owner is responsible for maintaining. It's important to note here that this bill only applies to a unit that is a single-family detached home and does not apply to a condominium or a unit that is a single-family attached home that shares one or more walls with another unit. Typically, generally, we all understand those to be townhomes, duplexes, or row homes, properties similar to those. So according to this bill, each association needs to select 3 pre-planned water-wise garden designs that will be used for installation in front yards within the common interest community. Plantselect.org is a website where you can go to look at the pre-planned designs that were suggested, or I guess included in the bill by the legislature. If the association has a website, it needs to post information concerning these pre-approved garden designs on the website. So moving a couple other important key items on Senate Bill 178 here. So first, an association must not prohibit the use of non-vegetative turf grass in the backyard of a residential property. So that doesn't necessarily say that they can't prohibit the use in the front yard or a side yard, only the backyard. Number two, an association will not unreasonably require the use of hardscape on more than 20% of the landscaping area of a unit owner's property. Number three, an association must allow a unit owner an option that consists of at least 80% drought-tolerant plantings. And finally, number four here, an association will not prohibit vegetable gardens in the front, back, or side yard of a unit owner's property. A vegetable garden, according to the bill, means a plot of ground or an elevated soil bed in which pollinator plants, flowers or vegetables or herbs, fruits, leafy greens, or other edible plants are cultivated. Finally, important to keep in mind here, if an association knowingly violates this act, the unit owner who's affected may bring a civil action to recover up to a maximum of $500 of the unit owner's $500 or the unit owner's actual damages, whichever is greater. All right, so we're going to move on to David's going to handle House Bill 23-1174. David?
I sure am. Just getting the video on. So 1174 is referred to by its formal name that you can see on the slide there, which again, I'm not going to read out because just due to its length, but again, this is another one of those bills that doesn't directly apply to the HOA Center, but it does apply to another topic that we have heard a lot about, especially of late, and that topic is insurance. So very many of you, I'm sure, are familiar with the Marshall Fire, which destroyed many communities throughout suburban Denver just over a year ago here, year and a quarter ago, approximately. But even if you're not aware of that fire, you've likely heard the names of other wildfires that have ravaged the state, or heard about other natural disasters across the state of Colorado. That could be hail, that could be tornadoes. Pretty much anything other than a hurricane, I think we're subject to here in Colorado. So these natural disasters, if you ask some, these disasters are frequent. They're increasing in frequency, and so due to that increase in frequency, House Bill 23-1174 is attempting to protect consumers by addressing some of the issues related to insurance. With that, could you go to the next slide? This bill was introduced back in February and was signed in May, and has an effective date of August 7th. So a brief summary of this bill is simply that the act requires that an annual report on the cost of reconstructing homes in Colorado be completed, and it requires that insurers must also mail by first-class mail to the named insured at least 60 days in advance on any notice of intent to cancel or to refuse to renew a policy. And again, this is something that we've been hearing more and more about in the HOA Center, is both specific homeowners insurance policies premiums increasing, but also the commercial policies that are covered by that are carried by the associations themselves. Next slide there, Nick. So there it's advancing. As the legislature has been concerned about the this increasing cost of reconstructing homes, the act is now requiring that the state put together an annual report that is due. The first one is due on April 1st of 2025, and then it will be submitted annually thereafter. And what this report really will cover is what's the actual cost of reconstructing homes in Colorado, and it's going to do everything that it can as a report to consider the various factors that go into reconstructing a home, such as differing regions of the state, different home types, different design structures, and different home customization types. With the next slide, what we want to talk about is what this bill does for homeowners in particular. Next slide, if you could advance there, Nick, sorry, is it's designed to protect homeowners from termination of those homeowners' policies. And as I mentioned briefly a moment ago, the act requires that insurers have to provide by first-class mail to the named insured at the last address shown on the insurer's records at least 60 days in advance of any notice of intent to cancel a policy or refuse to renew the policy. And furthermore, the notice has to specifically state the reason or reasons for the proposed action. It's worth noting, as we're finishing up on this, is that these provisions do not apply when a cancellation is for non-payment of premium, because in that case, it is not a required 60 days notice, but rather a 10 days notice. So that's an important distinction. If I refuse to renew your policy because it's just simply too much risk for my insurance company, I'm required to give you a 60-day notice. If you simply just didn't pay your premium to me, it's a 10-day notice. With that, next slide, Nick. And I think that I'll pass the buck back to you for perhaps the most questioned about bill in our current legislative session, and which is 1105. So there you are.
All right, thank you, David. The last bill that we're going to talk about today is House Bill 23-1105. The name of this bill is considering the creation of task forces to examine issues affecting certain homeowners' rights and creating the HOA Homeowners' Rights Task Force, as well as the Metropolitan District Homeowners' Rights Task Force, and making an appropriation. All right, this bill was introduced in January, signed on May 24th, and the effective date became May 24th, 2023. So basically, the Colorado General Assembly has made the determination that it should take a close look at the state of affairs surrounding common interest communities, as well as metropolitan districts in Colorado. While the General Assembly has already adopted the Colorado Common Interest Ownership Act, or KIOA, as well as the HOA Information Resource Center. Finally, in addition to Title 32 of the Colorado Revised Statutes, which address metro districts, this act creates two task forces to look further into the rights of homeowners living in common interest communities and metro districts. So specifically, what are these task forces going to be doing? They will meet to look at, and these items are laid out in the bill. Number one, issues confronting HOA homeowners' rights. Number two, fining authority and practices of associations. Number three, foreclosure practices. Number four, communications with HOA homeowners regarding association processes and HOA homeowners' rights and responsibilities. There's 8 total. Number 5, association records. What are association records? Basically a representative sample of association documents, such as the declaration, the covenants, the bylaws, the articles of incorporation, etc. That could also include the most recent reserve study, financial statements, records of actions by the board, and finally, any other rules and regulations. Number 6, HOA Center complaints. The task forces are going to examine HOA Center complaints if it so chooses. Number 7, complaints made to any homeowners advocacy groups. And finally, number 8, laws affecting common interest communities. So that's what the HOA task force is going to examine. The Metro District task force is somewhat similar, except a few minor changes. So that task force is going to look at tax levying authority and practices, foreclosure practices, communications with homeowners regarding Metro District processes and homeowners' rights and responsibilities, governance policies, how a Metro District could transition into a common interest community under Kiowa. And then finally, just as I'm starting to lose my voice here, the recommendations and report of the HOA Homeowners Rights Task Force. So importantly, there are deadlines in the bill that each task force has to abide by when they're submitting their reports on their findings. And those deadlines can be found in the actual bill. Finally, members of both task forces will be appointed by the governor's office and the legislature. And just wanted to let everyone know as well that as the HOA Center gathers more information on the makeup of the task force, the purpose, and what to expect, we will be sending out some information. The best way to keep apprised of that is to sign up for our HOA newsletter. That's on our website. If you scroll down all the way to the right, you'll see a search box or a email box where you can enter your email address and sign up for recurring HOA Center advisories and notifications. And on this slide here, there is a link in red there where you can go to our website and find our email, find out how to sign up for our newsletters. Okay, so that was the last bill that we're going to talk about today. Just as a reminder here, we do have summaries published on our website, and the summaries that we publish here are not intended to constitute legal advice and are provided just for informational and educational purposes only. But we did throw a link there where you can go to read the summaries on your own time. And if you have any questions, definitely feel free to email us your questions. And here's a slide. The white section there is our website. So if you scroll down, it's just a snippet of our website. If you scroll down, you can see these summaries under the drop-down tab, Kiowa, local, state, and federal laws. And then right there, where the big red arrow is pointing, 2023 legislative updates. And also we have our 2022 legislative updates there as well, in case you wanted to get a refresher or understand more about the laws that were passed in 2022. We did also want to mention, contact your legislature if you have questions about these bills. If there's something you're not sure of or just needed some clarification, the Colorado General Assembly's website does have a Find My Legislature tool, which is a great resource for A, identifying who your current representatives are, and B, how to reach out to them. So there's a link there for your convenience. And then finally, we're going to see, I don't know, if you have any questions in our chat that we haven't been able to answer, if perhaps David or even Amanda or I can see if we can answer these.
Absolutely. Let me jump in here. Mike asked, let's see, where is that question? At about 153, I think we've answered every question above 153 as Nick and Amanda are looking through here. But Mike's asking, the bill also requires that an HOA notify their members about the bill, and I'm assuming that that's going to be 1105, HB 23-1105. Yes, that is correct. They simply have to state to their unit owners, perhaps by email, perhaps by writing, perhaps at an annual meeting. Our recommendation would be that you do it in writing so that you can, as a board, can show that you did in fact comply with this requirement, but it simply requires that unit owners be advised of the existence of the HOA task force that is being created. A similar provision exists for the Metro District Task Force as well, but that's not for today. That's a Metro District Task Force, which is not why you all are here today. So, and it simply has to say that this bill exists and that a task force is being formed. A large number of individuals associations have taken some guidance and said, well, if you've got questions, reach out to the HOA Information Resource Center. And that's great. That's what we're here for. But I think, as Nick indicated somewhat here, the best way for communities to keep their homeowners informed of this would be to suggest that they register for emails to receive emails from our office through the HOA Today listserv. That would be honestly the most helpful information for them. Otherwise, they're still not going to be apprised of what's going on when we start to provide announcements such as who the appointees to the task force are, or when we announce, we will use that same system to announce when the first meeting is. So that's going to be the best way to inform your community members to stay apprised. Simply saying, call the HOA Center isn't the most helpful thing, because ultimately what we'll do then is say, well, sign up for the HOA Today listserv. So it would certainly be a big favor to us for any of your communities that have not notified your communities yet, your community owners about this yet, to suggest that they register for the HOA Today listserv. Again, we don't email lots and lots on there, and as soon as this, if they're no longer interested in HOAs after the task force has convened its business, they can unsubscribe. But we will keep those communications to a minimum so that we don't overburden anybody or cause any email fatigue. We appreciate that. We all get too many emails in this world. So there, Mike, is you're referencing the specific section there about the task force notifying its owners before the first meeting. So at right now, I would hazard a guess that the meetings will be convened. The first meeting will be convened sometime in early August, once appointments have been made. That's going to be subject to the task force and the task force's availability upon appointment. So, but my recommendation to you all would be to not delay in getting that notification out to your unit owners if you're on a board or if you're a community association manager that's joined us today. I think the next question I'm seeing is, actually, Nick, do you have anything that you'd like to address?
No, thanks, Dave.
Okay. Pat is asking what our website address is. I will provide that to you in just one moment in the chat here. Bear with me. I just have to scroll up. It's at the very beginning here, but if you joined us even a minute or two late, sometimes it doesn't get put in. I don't think you get to see the back. So I just included information on how to access the HOA Information's website. The very last question that just popped up is, who do you contact to volunteer for the task force? At this point, Sally, the task forces have closed the application process because the bill specifically says that the appointments need to take place by August 1st. And so we're now 9 days away from that. The application process closed earlier this month, and both the governor's office as well as the Speaker of the House have been convening and having interviews for those appointments, and I would suspect that information will be shared with our office at some point here, but I can't say when, other than I would expect it to be shared with us before August 1st, which is the appointment deadline. But nevertheless, even though the applications to be a task force member have been closed, that does not foreclose you from participating in the process. Nick mentioned a tool that we are in the process of developing that we will open up to the public for stakeholder engagement and public comments in the near future here. And again, the best way to be notified of that is to sign up for those HOA Today emails from our office, where we will, it's basically a website tool where you will be able to share your experiences, good, bad, or indifferent, about HOAs, whether you're a board member, an attorney, a CAM, a homeowner, or a tenant, or just somebody that says, hey, there's a HOA across the street and I have some ideas. You don't have to live in an HOA in order to be an interested party and someone that provides input and insight to the task force members here. I think that that's very important. But again, that web tool will be available in the near future, and the best way to get that information is through the HOA Today listservs. Jeanette's asking when this webinar will be available, and as always, these webinars are available usually within a few days. We do our best to get them up and posted to our YouTube site and to our website early in the following week. So there's some technical aspects that we have to do with these before we get them up onto the YouTube page, but they will be available in the near future here. Again, I'm going to put the link to where you can find those both this forum as well as future forums. Well, this forum once it's been posted, and all of our previous forums that is now in the is in the chat.
All right, thanks, David. And also, we tried our best to answer most of the questions pertaining to the bills, but of course, if there was any more in detail or in-depth questions, feel free to or please email us at, I posted there in the chat, Dora_Dre DRE _ HOA inquiries at state.co.us. We'll do our best to respond. Let me see if there was anything else here.
Just one inquiry from Anne, and she's just asking how what the best way to reach out to the HOA Center is, and I'm going to put in the chat right now the email address that's going to be the best way to reach out to Nick, and just because it sounds like you've got some specific questions that you'd like to address, and so Nick should be able to help you out with that, and hopefully get you some information and resources that will aid you on your way here. So
all right, and with that, it's about 2:03 in the afternoon here on Friday, and I think we're gonna wrap it up here. We just wanted to thank everyone again for attending today. We really appreciate you coming and wanting to learn more about HOAs. It's a never-ending quest to have the knowledge about associations, it seems. And I'll be the first to admit, I don't know everything either. And sometimes I have to do some research or bug David or whatnot. But again, thank you all so much for coming today. And we'll see you next month. We hope you continue to attend. And thanks again, everyone. Have a great weekend.